Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, been holding up half the sky. Raise your hand if you're ready and willing, if you know it's time. Time for a girl on time. Time for a girl on time. Time for
Hello, everybody. I'm Michelle, Cheryl, Beverly, Bill, narrating my life. Love it. Polkaroo, cellulite yoga pants, Beverly, did I say that? Chuck, Vicky, I hope you feel better. Lisa B was here, Amy Lane, and Vicky was first. Now that we've gone over that, Ed's here as well. Hi, 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 hi. We are here indeed to finish off, what should we call it? The bathtub bonanza? Ah! Miss Donna, Orlando Chiquita, bathtub bonanza. Do. Thank you so much. How is the weather? We are in a bit of a heat zone right now. Thank you so much. That's so sweet. In the bathtub right now. I like that. I like that. And thank you so much, Miss Donna. Yes, for supporting the channel. Oh no, you got dengue? I think they call it dengue. Dengue. You got dengue fever? I think it's sometimes called, like, I would have called it dengue fever, but I think it's dengue. That's pretty serious, Cheryl. Shit. Sending good vibes. Say hi to you. Not as hot as some other places. I get that. Amy's gotten very hot. Only 107 degrees. Ah! Oh gosh. Let's just look at my weather before we get down to this ruling that we have coming up today. Finally, not a cock block. It's 84 degrees right now, and there is 34% humidity, so I don't think that's very much. Anyways. Oh yeah. I have two things to, well, actually I'm gonna bury those subjects in this video. So if somebody wants to know about them, they'll have to wait a little bit longer. 2 weeks. Oh my gosh. Feel better. 84. I mean, it's very hot here because there's no air conditioning, and the room that I'm in is actually like used to be the outside of the house, I think, and so it's just not insulated or vented. I don't know what it is. Anyways, let's get going with what the ruling from the bathtub case. I think I linked them in the description. I definitely linked them on the other videos. I'm pretty sure I linked it in this one. But anyways, we have 4 parts. This is part 4. Let's get to it. Hi, Mr. Hector. Hi, Tammy. Also, you guys, I'm having tacos for dinner. Hi, Courtney. I thought I was making tacos for other people. Yeah, we can do a poll. Well, why don't we take the opportunity now to put what we think the outcome will be for this? But oh, Judge looking slick. Did he get his hair done? Oh, Mr. Moldova. But yeah, it is Taco Tuesday, and I
Good
am.
afternoon, Judge.
Good afternoon.
Oh my God, Mr. Schaefer, you're too close. I will hit play here in just 1 second, but I'm just going to tell you my plan. So originally, I was making dinner for other people. I have now been abandoned. And so I feel like I might make myself just a really gourmet guacamole. I'm going to make myself taco night. I don't care. I'm going to do it anyway. It's happening. I am currently trying to ripen an avocado using ethylene gas and a paper bag. So hopefully that ripens by the time I figure it out.
Modeman is your client with you?
He is not. I think he's supposed to be zooming in.
Oh, okay. I assumed that he was with you. That's why I brought everybody in.
Yeah, I thought so. I thought he'd come here too. But
Okay. Then, okay, we have to wait a little bit more then.
I will try to.
Please try to contact him, yes, so he can get on Zoom.
Okay.
Apparently the ethylene gas that so the way that I'm doing it is by putting a ripe apple. Oh goodness, Victoria. A ripe apple in a paper bag with the avocado, and the ethylene gas that it releases naturally makes other fruits and veggies ripen, which is why some of those like bags or containers that they sell you in your fridge can keep it from ripening, or they sort of regulate the ripening process. That's a good idea, Shasta Rob. Frozen avocado is something I probably like because I bet it freezes quicker than it ripens, or no, it thaws quicker than it ripens, right? Normally, how I do it, no, that comes from all of the. I looked at it. I don't have a banana, so I went with the apple that was almost rotting. So I think it's emitting something. But I what I tend to do is buy avocados and I leave them on the counter, and as soon as they're ripened to the point you want them, put them in the fridge. And they stay at that point for quite a while. Cynthia's got the same idea as Rob. So I should get a bag of frozen avocado and then just thaw it, I guess, ahead of time. I don't know. Um, I don't think it would hold too much water. I think they would just freeze it. So, but I unfortunately I didn't buy the avocado. Like I did a grocery order online, so I didn't pick my own avocado. Um, and avocado is actually the best first food for babies, by the way. It's portable. You don't need to cook it. It comes in its own container. It's very good for brain development, and its flavor is very mild. And it's not sweet, which is another good thing. So if you put that on, if you give that to a baby as their first food, it's actually a very well received first solid food, and it's natural. Like I know a lot of people go for baby cereals and stuff, but in reality, a whole food like that, unprocessed, is better. Um, Obviously, your mileage may vary, but avocado was a great little snack for my daughter when she was younger. And again, like I said, portable, but bananas are too, but they're sweet, and you don't necessarily want to give them a sweet tooth constantly at the get-go. Although my daughter ate so much sweet potato and carrot that her nose turned orange. I'm not joking. I have pictures of her up here with her nose orange. And that actually happens when there's too much of I think it's carotene or whatever it is, but it's natural. But it does happen. So oh, Ed, I like an avocado shake. Oh, Hector, That's a humble brag. An avocado tree. 3 large eggs for 1 avocado, Cynthia? Dang. Dang. For wee babies, her nose was orange. I'm looking at the picture right now. It's funny. Anyways, let me zip this forward, see when they showed up. Oh, wow. I would have been talking for a while.
Thank you, Judge. I have Jesse on the phone.
That's fine.
Okay, just a moment, please, and I have to get the record going and then we can proceed. We're now on the record for case number 2023-2589 DM, Victoria Bavra versus Jesus de la Torre Bavra. It is Tuesday, July 9th, 2024 at 1:39 p.m. Attorney Schaefer for the plaintiff and Attorney Waldman for the defendant.
Good afternoon to everyone.
Good afternoon, Judge.
Court will
afternoon.
note, as Mr. Moldovan has stated, his client is appearing on phone as he was not able to get on and zoom in, but he's appearing and hearing by phone. This matter is heard for trial on May 31st, 2024, and continued on June 27, 2004, at which time we concluded. Is there anything else, Mr. Schaefer, before the court grants its ruling?
I don't believe so, Your Honor.
Okay, Mr. Moldovan?
Nothing, Your Honor. Thank you.
Okay, thank you. Well, court will first.
Well, sorry, Judge, you didn't ask me, but I do have something to say as somebody who's watched this entire proceeding. Folks, don't let the hate for your spouse or former spouse outweigh the love for your children. Be a bigger person, even if it's harder to do. These people were fighting over nothing. We see cases where people are fighting over serious things. These people were fighting over nothing. And I personally think that it's hard at the get-go, but if you work through it, it will pay dividends in the end if you do not fight with your former spouse like this. It's better for your mental health, it's better for the kids. But really, fuck them kids, right? Fuck them kids. All right. Now I'll shut up for a little bit. That's what she said.
Find that the testimony in this case does provide a statutory or satisfy the statutory basis for a granting of divorce, so the court will grant the divorce. The parties were married on July 7, 2017 and separated approximately January 1, 2023. So we have approximately a 5.5-year marriage. The parties have 3 children, Ava 8, Everly 5, and Eli 2. In this matter, the court always has and always looks at credibility of again, the parties in every case. In this case, as it relates, unlike in many cases I have, is the court did not find really any substantial contradictions between the testimony, and the court did find that both of the parties were credible in the testimony that they provided. The plaintiff had originally requested physical custody in her complaint. However, the court would note both attorneys acknowledged on closing that this case was appropriate for an award of joint legal and joint physical custody. Pursuant to MCL 722.26A, the court must advise the parties of joint custody, and the court shall consider the factors under the Child Custody Act as delineated under MCL 722.23 and determine if the parents will be able to cooperate and generally agree concerning important decisions affecting the welfare of the children. Before I go through and examine the best interest factors, the court must determine whether an established custodial environment exists. An established custodial environment exists if over an appreciable time, the children naturally look to the custodian in that environment for guidance, discipline, necessity of life, and parental comfort. During the time that the parties were together, the evidence was shown that they both participated in the raising of the children. There has been no evidence that would refute this. Pursuant to the case of Bathtub versus Bathtub at 332 Mich. App 232, a 2020 case, the court recognized that parents can fulfill different needs and role in providing security, stability, and permanence. Recognizing this distinction, the court stated that although different, where each parent regularly and routinely is involved in the child's or the children's daily care, an established custodial environment may exist in both homes. Recently, in the case of Sabatine versus Sabatine, a Supreme Court case that was just handed down last
Oh,
month.
Your Honor, I'm sorry. Something happened to my sound.
You lost your sound?
I can't hear right now, Your Honor.
Okay, well, we weren't saying anything, but I guess I can keep talking until such time as you may find, you can hear now?
I can hear, sorry.
Did you hear the part when I was referencing the Bathtub case?
That was about right where you, it was right after that where it cut out. So,
Okay. I was gonna say, in the recent case of Sabatine versus Sabatine, it was decided last month, the Supreme Court held that the court must look at the circumstances at the time that the court is making its decision to determine whether an established custodial environment exists. In this case, the parties separated, I said previously, on or about January 1, 2023. At that time, the parties agreed to parenting time with plaintiff Friday through Monday, and plaintiff testified that within a few weeks, the parenting time schedule changed to Friday at approximately 3:00 p.m. through Tuesday morning, when defendant would pick up the children and take them to school. Defendant claims that the present schedule started after the school year began and was supposed to be only temporary schedule. Notwithstanding what either of the parties thought, the current schedule has continued for either a year or 9 months, depending upon which rendition of the testimony is accurate. Both parties testified about their relationship with the children. They testified that they have a close, loving relationship and that they have both provided guidance to the children and that the relationship is permanent. Based upon all of the testimony, it is clear that an established custodial environment does exist in the home of both of the parties. As a result, and I believe that this is why at closing that both the attorneys confirm that this should continue. When an established custodial environment exists, the court cannot change custody unless the parties present clear and convincing evidence. The court should do so. The court will now examine the best interest of each child test. As delineated in this matter under MCL 722.23. The first factor the court has to look at is the love, affection, and other emotional ties existing between the parties involved and the children. Both of the parties testified that they love, have affection, and are bonded to the children. Plaintiff testified that her relationship with the children was strong. They're comfortable with her, and she is consistent. She is comfortable. So she testified she's comfortable with defendant's care of the children. Ekaterina Cole, the plaintiff's sister, testified that plaintiff and the children have a very
It's Ekaterina. wasn't it? A Katerina, Katerina.
Close relationship, and William Inman testified that plaintiff and the children have a close relationship. Defendant testified how he hugs and kisses the children and they reciprocate to him, and that the children love to sleep with him and there is a tight bond between he and the children. I also consider all the other testimony, but that is just a highlight. And in this case, when I do so, I find that this factor weighs equally as to both parents. Next factor is the capacity and disposition of the parties involved to give the children love, affection, guidance, and continuation in the education of raising the children in their particular religion or creed. It appears that both parties have provided the children with a loving, affectionate home and provided guidance and continue them in their education, although there is a dispute over the school, and I will address that later. Neither party addressed any religious upbringing in this case. So the court would not consider that as it relates to this factor. When I look at, again, the testimony presented and all the evidence, the court does believe that this factor weighs equally as to both parties. Next factor is the capacity and disposition of the parties involved to provide the children with food, clothing, medical care, and other remedial care recognized or permitted under the laws of the state in place of medical care and other material needs. Both of the parties have demonstrated their ability to provide for the material needs of the children. Plaintiff has complained that defendant didn't acquire full-time employment to provide medical insurance. However, the court would note that the children were on Medicaid for a time before plaintiff acquired health insurance for them. The testimony also showed that both of the parties have provided for the medical needs while the children are in their respective care. They also have been able to and have provided for the material needs, clothing, food, all of those material needs while the children are with them. So the court will weigh this factor equal as to both parties. Next factor is the length of time that the children have lived in a stable, satisfactory environment and the desirability of maintaining continuity. Court will note that the plaintiff testified she purchased a home in Battle Creek after separation. She testified that the parties did reside in the home that defendant is for a few years before separation. She stated that the home was adequate at that time. She testified that the house only has one bedroom. However, defendant testified that the house has two bedrooms. He also testified he has planned to add 3 bedrooms and a bathroom now that he has had his plans approved for a new septic system. Plaintiff testified she desires to move to Marshall, where her family resides. William Inman testified that plaintiff's home is appropriate, and the court believes that both of the residents of the parties are stable and satisfactory. As a result, the court will weigh this factor equal as to both of the parties. Next factor is the permanency of the family unit of the existing or proposed custodial home or homes. In this case, neither of the parties testified that they were dating anyone seriously, although both have dated following the separation. As a result, the court will weigh this factor equally. Next factor is the moral fitness of the parties involved. Plaintiff testified she has no criminal record. Defendant testified that he had a DUI back in 2012 before he met plaintiff and had children. And defendant testified that he stopped drinking in 2015 and has not had anything to drink during the marriage. Court does not note or had heard any other testimony about the moral fitness of the parties. As a result, the court will find this factor weighs equally as to both parties. Next factor is the mental and physical health of the parties. There's been no testimony that either party has any mental or physical health issues, and as a result, the court will weigh that factor equally. Next factor is the homeschool and community record of the children. Court will note that Ava and Everly attend Gull Lake schools where they have attended their entire lives.
Weigh this factor, Judge. Chris, Thank you so much. Countdown to your birthday. Do. You rock. These are sort of boring, but this is in fact this is what it boils down to in these cases. The judge weighs these factors, and I know we joke about him wordling along or playing Angry Birds or Farmville or whatever, but in reality, he's paying attention like a hawk. He's listing out shit. He's writing his ruling as he's doing this, I think. I know. I got your factor right here. Thanks again, Chris.
Ava completed third grade. Everly just completed kindergarten. The parties did testify that the children are doing well in school and that they have friends. It did appear that Everly did miss, or Ava did miss, a significant number of days of school.
Well, he says significant, but we literally covered a case the other day where there was like 60 something or 80. So these kids weren't that bad at all. We haven't really heard from the lawyers today, though. This is the ruling. I'll shut up.
And plaintiff proposes a move that would change the children's school. This would, of course, if she were to do that, would be a substantial change in the children's lives if they were to have to move school. As a result of her desire to change the school, the court will find that this factor does slightly favor defense.
He didn't say homeschool. He did say homeschool, but he meant home, comma, school, Navar. He's listing out first the 10 factors. Or not 10, I guess there's like 14 or whatever, but they are, one of them is home, comma, school. And that's what he said. The children, there was no homeschooling ever proposed. These children have already been enrolled in school, and the decision was about which school to either continue sending them to or whatever, but there's no homeschool as part of this. He literally just said home, comma, school. You're on vacation for 10 days? I love it.
And its father. Next factor is the reasonable preference of the children. In this case, the court did interview Ava and Everly. I did not interview Eli as he is too young. The court has found the girls to be pleasant, polite, and the court will consider their preference for purposes of the best interest. Next factor is the willingness and ability of each of the parents to facilitate and encourage a close and continued parent-child relationship between the child and other parent in this matter. It does appear that the parties have attempted to accommodate each other's schedules. Each professed a willingness to continue to cooperate, and the defendant, however, did raise the issue the plaintiff did not provide him with any holiday parenting time in the last year except for Father's Day. The court does believe that the parties will be able to facilitate this in the future, and as a result, the court will weigh this factor equally. The next factor is domestic violence, regardless of whether the violence was directed against or witnessed by the children. Each of the parties testified that there was no domestic violence during the marriage. As a result, the court will not consider this factor. The last factor is any other factors the court considers to be relevant in the child custody dispute. The court doesn't believe that based upon the testimony, there's been any other factors in this particular matter. The court notes that as the court considers the factors, the court does not weigh them like baseball box scores, and the appellate courts have held that the court can give greater weight to any of the factors and not consider factors that may not be relevant. When I weigh the factors, the court finds that there is not clear and convincing evidence sufficient to change the established custodial environment in this case, and the court will therefore grant the parties joint legal and joint physical custody. Court then has to look at, under parenting time as provided for under MCL 722.27A. It is presumed pursuant to the statute that best interest of the child if they have a strong relationship with both parents. Under subsection I, the court has to evaluate the best interest factors that are
The best interest factors of Christopher's birthday week. Thank you, Chris. You rock. Make sure you have gifting turned on. Members only is on Sundays. We do 2 shows on Sundays, doubleheader. Who doesn't love banging it out twice on a Sunday?
in dispute. Court has to consider the following factors. Number one, special circumstances or needs of the children. The court does not believe that there's any substantial circumstances or needs that the court would need to consider in this case. Next is whether the child who is less than 1, the child is not, Eli is 2, and so the court will not consider that factor. Next factor, likelihood of abuse or neglect of the children during parenting time. There's been absolutely no testimony about any abuse of the children during parenting time, so the court will not consider that. Next factor, likelihood of abuse of a parent during the exercise of parenting time. Likewise, there's been no testimony about either party being abused, so the court will not give any weight to that. Next factor is inconvenience or burdensome impact of travel on the children. In this case, even though there's some distance, the children are still, again, within a reasonable distance from each of the parents, and the court will find that the transportation is not burdensome in this particular matter. Next factor is whether a parent can reasonably be expected to exercise ordered parenting time. They have exercised all of their parenting time so far. The court believes that they would in the future, and therefore the court doesn't find any, I guess you'd say, exception in this particular matter. Next factor is whether parents frequently fail to exercise parenting time, which the testimony has shown that they have not. Next is threatened or actual detention of the child or children. There's been no testimony about any detention of the children. And the last is any other relevant factors. In this case, the plaintiff testified she wants the current schedule to continue. She does not want the children in daycare and believes that if the current schedule is not maintained, she will have to find another job. Her employer made accommodation for her by allowing her to have Monday off and to go in later on Tuesday to accommodate the time with the children. Defendant states that he has not had a holiday, as I stated in the last year, except Father's Day, nor has he had a weekend. The current schedule has been working well and accommodating the work schedule of both parties. As a result, the court does believe it is appropriate based upon the best interest factors as the court had previously examined, as well as the factors under MCL 722.27A parens 1, that the current schedule is working, and the court will continue the current schedule with the following exception. The parties will alternate holidays, with defendant having the next holiday, which would be Labor Day, and then alternating each holiday thereafter. Defendant will also receive the first weekend of each month, in which the entire weekend falls within the month from Friday, 6 o'clock p.m. through Sunday at 6 o'clock p.m. By example, in August, the first weekend starts on August 2nd, 2024, and the defendant shall receive that weekend. If the first weekend includes a holiday that is the plaintiff's holiday, whereby she would be entitled to an extended weekend, then the defendant would not get that first weekend, but would receive the second weekend of the month. To compensate plaintiff for this missed time, she would receive an overnight during the month from 6:00 p.m. to 6:00 p.m. on the next day. And it would be a day of her choice when she provides defendant 5 days notice of the day she wishes to receive. However, her makeup time she would not be entitled to receive a holiday or time on the defendant's weekend, but on the other days. Each party would receive 2 weeks of summer vacation, which they will take precedent over the other parenting time, however, not the holidays, upon providing 30 days notice to the other party. The 2 weeks will not, as I said, would not include a holiday, and the only one that would really be applicable is the 4th of July for the party that would receive that day. The next matter the court has to consider is school. In this case, as I stated, Ava and Everly currently attend Gull Lake Public Schools. Ava completed 3rd grade, Everly completed kindergarten. Neither child went to another school their entire lives. They're both doing well, have friends. Gull Lake is currently a school of choice, but after next school year, the children would be considered permanent students. Plaintiff did continue the children enrolled in Gull Lake schools for the next year. Plaintiff has proposed the children would go to Penfield or Marshall, which would be a school of choice as well. And the parties both testified that they agreed that testified that the parties had agreed to have the children in Gull Lake schools when Ava first started back in 2020. Plaintiff testified that if the current parenting time schedule continues, it is fine to keep the children in Gull Lake. Plaintiff testified that when the parties discussed the children going to school, they chose Gull Lake because it was the best school around. Defendant testified that his and his family's connection with the Gull Lake schools. Court would inform the parties, as no one brought this up, but maybe it's just too early. Court would inform the parties that Gull Lake has a legacy scholarship program that'll pay for 2 years of college at KCC for students that attend kindergarten through 12th grade. After considering all the evidence, the court will order that the children would attend Gull Lake schools until they graduate from high school, or the parties would otherwise agree to change the school, which they would have to do in writing. Next, the court will address the issue of child support. Plaintiff is employed at Gallagher Uniform. She testified in 2023. She made between $53,000 and $56,000, and the court will take $55,000 as her income for calculation of support. She testified she has an insurance premium of $345 per month for her and the 3 children. When the court looks at this individually, that is a cost per child of $86.25 times the 3 children will result in a $258.75 deduction from her income for purposes of calculating child support. The defendant's job is flipping homes. He testified his income in 2023 was $34,000, but he anticipated making between $45,000 and $50,000 in 2024. He did testify that he had just in the past month had sold a house and flipped it. So what the court will do is the court will use $48,000 for his income for purposes of calculating support. Parties had also raised the issue of tax exemption for the children. Plaintiff took the deduction for all children in 2023. The defendant proposed that the parties would each take the.
Thanks, Chris. Have a good dinner. Love you. Where are you going for dinner? Have a good dinner. I hope they have bread. Eat lots of it. she's not getting what she wanted, even though the status quo remains. Evidently, she wanted a lot. And like I said, don't put your fate in the hands of a judge who sits and does Wordle all day. Yeah, they do have bread, right, Chris? Jealous. Enjoy. Love ya. Paul, he's ruling, and basically nothing's changing so far. Oh, Dad got one a weekend a month and alternating holidays, I think.
Deduction for one child and alternate on the third child. This appears to be fair and reasonable to the court. And so for the tax year 2024, defendant will receive the tax deduction for two children and plaintiff will receive the deduction for one child. And then thereafter, they will each alternate the deduction for the one child. Once a child would drop off, as it would be, because Ava would be the oldest. When Ava drops off, then the parties would each claim one child after the year that they were able to claim the two. And then when both children are off, when Ava and Everly off, then they would alternate years for Eli.
Damn, Judge thought of everything. He's literally just planned like 20 years in advance. No, seriously, like 18 years or 16 years until all of the kids are emancipated. Damn. Plato gets one child and a bathtub.
With that, I believe that the court has addressed all the issues the court had to decide. Mr. Schaefer, is there anything you believe that the court had missed or failed to address before we conclude?
No, I believe you have covered it.
Okay, Mr. Moldovan, likewise, is there anything you believe I've missed or failed to address before we close the record?
The one thing I may have missed it. Did you say it a child support effective date, Your Honor, or was that upon entry of judgment?
The court will, I did not address the effective date. The court will make the effective date, the last date of trial being June 27, 2024. Thank you for addressing that, Mr. Moldovan. Anything else?
Nothing further, Your Honor.
Okay, thank you. I'll ask.
The judge, I would normally cut it off, but I want you to listen to what the judge says at the end. It's a little bit funny, has something to do with us. Then we have one more hearing for us to watch tonight. I had something else, but it didn't actually download properly. So I found something else for us, but let's just finish off this.
Ask that Mr. Schaefer would prepare that as he represents the plaintiff. And just Mr. Moldovan, for your information on, this is all on YouTube. We keep these up for a matter of 30 days so that the attorneys can go back over, because I know we address a lot of things and you may want to, in preparing the judgment, go back and clarify some points. So it'll be held up for 30 days and then they'll be taken down.
All right. Thank you, Your Honor.
Okay. Thank you all. You're free to go. Have a wonderful day and I wish you all the best.
Thank you.
Thank you.
30 days on YouTube. Well, you know, that's the first time I've ever heard them talk about two parents' income. Generally, they only talk about the one parent's income. So I'm actually hopeful that they are going to sort of split it. The way that it works where I live in British Columbia is if you share custody, you take each person's income and you see what they would pay for one child or however many children there are. And then you do that for each person on their own. And then you take the two amounts and you pay the difference. So that's sort of the fairest way to do it that I can think of. Each person uses the calculator for the child support amount and then they pay the difference. Whoever makes more, usually. I don't think that's what she wanted, but I think that's what she got. Let's go over to Bronlick now. Judge Cranky. Oh, jeez. How?
She's got Wyatt. Only one we got out there, sister. Tim hasn't come in yet. Should I get it?
Oh wait, I just remembered the one that I got that I'll. It's actually got to be one of the craziest requests I've heard in a long time in terms of reducing an amount owed.
But not till later for mine. That's what I thought too, like later.
You're talking about me or her, Navar?
Page 1, Maria Wyatt versus Kevin Wyatt.
For the record, this matter is before the court on the plaintiff's motion for order to show cause, seeking enforcement of the terms of a judgment of divorce. This hearing is being conducted via Zoom. President's attorney Leah Worka, representing the plaintiff Maria Wyatt. Ms. Wyatt appears to be present. Good morning, Ms. Worka.
Good morning, Your Honor.
Why is the judge not on the screen? I'm confused. I'm confused.
Is Kevin Wyatt present on audio?
Can you hear me or?
Yes. Are you
Yes.
Kevin Wyatt?
Yes, I am.
Right. Good morning, Mr. Wyatt.
Good morning.
You and Ms. Wyatt and Ms. Worka have conferred with the friend of the court, I believe Ms. LaPrada this morning. Ms. LaPrada has provided the court with fine recommendation that Kevin shall pay to Maria $21,183.49 pursuant to the terms of the judgment. Upon proof of payments, Ms. White will pay to Mr. White any payments since January of 2024. I'm not sure what that means exactly, but perhaps Ms. Worker can explain. Further, it's recommended that Ms. White shall receive the title to the Jeep as well as release of lien as soon as it is paid in full. And Ms. White agrees to keep the Jeep in full from her settlement. The issue of attorney fees is reserved. That is a recommendation. Ms. Worker, is this recommendation agree with your client this morning?
For the most part, Your Honor, point of clarification on the provision, the recommendation regarding the payment since January of 2024. Admittedly, the divorce judgment did order that my client would begin making those payments as of January. She did not, in part, Mr. Wyatt was not cooperative with giving her the information she needed to make the payment to the current lien holder. However, the other provision of the judgment of divorce was that Mr. Wyatt was to pay her the lump sum of $123,500 within 90 days of entry, which would have been February 15th. He didn't do that. He gave her a partial payment on May 8th, which would have been 173 days after entry of the judgment. My client's position is that she should be responsible for those payments since the funds were paid to her in May, or the partial payment. Outside of that, the recommendation is agreeable. My client is requesting a total of $900 in attorney's fees plus her $20 filing fee for having to file the petition for show cause.
Okay, what's this in terms of upon proof of payments, Ms. Wyatt should pay Mr. Wyatt any payments since January of 2024. What's that, payments on the Jeep?
That's correct, Your Honor. Mr. Wyatt is stating that he has made those payments on the vehicle monthly since January. We don't have any verification of any payments that were made. There's another issue that my client attempted to make an $1,100 payment on that loan on June 24th, which was later canceled. In a text message, Mr. Wyatt had indicated to her that he canceled it because he didn't know where the payment came from. That $1,100 was never returned to my client's bank account, and we don't have a way of knowing whether or not it was applied to the balance of the loan. We don't know. She knows who the credit union is that holds the loan. They refuse to give her any information because she is not listed on the loan. It is in Mr. Wyatt's name alone.
Was Ms. White gone online to check whether or not her check was negotiable?
Mama Llama, we thought you went on the cruise already. I was jelly, but it's okay. We're glad to see you today, Miami, for 2 days, then a cruise for 5. I'm so jealous. Oh, you have a passport, right? You need passports for cruises, people.
It
did clear her account, but Mr. Wyatt indicated in a text message that the payment was canceled. However, it was never returned to her. So I would assume a statement with payment history would indicate whether that $1,100 was in fact applied to the vehicle loan or not. If it wasn't, then we'll have another issue to try and figure out where her $1,100 went.
If this recommendation, I'm just confused, says upon proof payments that Maria shall pay to Kevin any payments that she made since January 2024.
Upon proof of payments made by Mr. Wyatt, then from January until now, my client would reimburse him the amount of those payments made, is my understanding of the intent.
Okay, all right. I just want to make sure. And you agree with the $21,183.49? That's the remaining balance of the lump sum due per the judgment.
Yes, Your Honor, by my math, that is the amount that she is owed from that. And again, our disagreement with the recommendation would be payments since January. We would be requesting payments as of May.
I'm sorry, I'm not quite following you. The recommendation is about proof payments. Mr. White paid Mr. White any payments since January. You're saying any payments since May?
That's our request.
Okay. And the basis for that?
Is the almost 3 months. The lump sum that she received was paid nearly 3 months after it was ordered to have been paid. Also, my client did attempt on multiple occasions to get the information from Mr. Wyatt to be able to make those payments. He refused or failed to do so. So that's why we're requesting since May. It was not her fault that he failed to pay her when he was ordered to do so.
Has the Jeep been paid in full? Do we know that?
Not as far as I know, Your Honor.
Okay, who's making the payments right now?
Mr. Wyatt claims that he is.
Mr. Wyatt, how many payments are left? Let's get this Jeep paid off and done with.
I don't know exactly how many payments, but it's like, the balance is like $19,000. And, she knew who the mortgage company was or the finance company all along.
But
So
it's
it
in
could
your
have been
name,
handled
Mr.
at
Wyatt,
any
so they won't
time.
release information. Maybe Ms. Work, you need to subpoena those records.
Your Honor, I can do that. My client is happy to pay the payoff once we know what it is. But again, they will not give her that information without Mr. Wyatt's cooperation.
Well, you can subpoena those records, can you not?
I could, that would have increased my client's attorney's fees.
You can be given any records you want on the Jeep and we can resolve this. And if she gives me the back payments, I will give her, we can resolve on the payoff and I'll give her that amount back. Less the payments
Who's the lien
since
holder? Is it
January.
credit union?
It's a credit union, NASA Federal Credit Union.
Okay, do they have a local branch so the two of you can meet at the credit union and go into the bank and get printouts of all this information?
No, they do not. They're stationed, located in Virginia.
Okay, Well, Mr. Wyatt, since the loan is in your name, they will not provide that information to Mr. White. You need to get the printouts of all that.
I can get all the printouts and anything on this Jeep, and I think we can resolve this with Leah and Maria. Simple.
Okay, so it's obviously there's too many moving parts here. The court's inclined to put this over for a couple weeks. Get that information, Mr. Wyatt, so we can finalize this. And you need to pay that to come up with that 21,000. Where are you gonna get that money from?
I have the 21,000, but I'm saying it would be less the payments of the Jeep that I've made so far since January.
Okay, well, you need to provide the documentation of all that. Why couldn't we have done that before today?
I don't understand why we can't. I have a phone and I haven't heard any requests. I did not see a request on the finance company, let alone Maria knew who the finance company was.
Again, Your Honor, I know the court is aware that just knowing who holds the lien does not facilitate the transfer of information where my client is able to resolve the issue. They will not speak with her or give her information because she's not on the account.
That's understandable. So you understand that, Mr. Wyatt, you need to get all information. They will not speak with Ms. Wyatt unless the two of you can have coffee and get on the phone together.
Yeah, I mean, we can resolve this some.
Okay,
easy.
how do you suggest we resolve this, Mr. Wyatt?
I will get all the payment. We'll find out where her $1,100 went, whether it was applied to the loan or not. All the information the finance company should be able to produce, or I can get it online and give those papers to Leah and then resolve the payoff. And I will give Maria the money for the rest of the payoff.
All right, how much time do you need? Can you do that in a week or two?
Yes, I can. I
Right,
can
Ms.
call it
Werka?
right after. Yes, sir.
Well, the court suggesting let's just adjourn this for a couple of weeks. Mr. Wyatt seems to be willing to secure the necessary information, get the Jeep paid off, and as well as pay any amount that's owed to Maria. We can come back and address these things.
But that would be agreeable to me, Your Honor.
Let's at least give that a try. So maybe we look at 31st. We could even do it on Monday. What about July 23rd in the morning, 10:15?
That's a Tuesday.
Your Honor, I have an appointment that morning. I could be available early afternoon.
Can't do it. Can you move that appointment? I guess we'll look at the 30th or 31st then.
I can't move that appointment. The 30th or the 31st, I'm open.
Okay. How about July 31st at 2:30?
That works for me, Your Honor.
Right, will that work for you? July 31st, it's a Wednesday at 2:30 in the
Yes,
afternoon,
sir.
Mr. Wyatt?
At 2:30
Correct.
in the afternoon?
Correct.
Yes, that works for me.
You're still at 1344 Yench Road, Dundee?
Yes, sir.
All right, the clerk's gonna print out this recommendation just for the court's information, Mr. Pratt. Thank you for that, and if we can just do a revised recommendation.
Yes, sir.
That the matter is adjourned to July 21st, 2:30 p.m. so that Mr. White can secure relevant information from the Jeep lien holder. And provide that information to Ms. Rourke. You don't need to wait till the couple days before, Mr. White. Work on that this week. Get it to Ms.
Oh,
Rourke
no, it
ahead
will
of
be
time.
given to her as soon as possible. And the easiest thing is if I figure out the access passwords, I will give them to her and she can look at this whole thing online.
Okay, that'd be wonderful.
Yeah.
So share that information as soon as possible. And if in fact it's resolved, Ms. Worker can always contact the court and say, Judge, we don't need to come back to court.
Okay, that sounds good to me.
Right, anything further this morning, Ms. Worka?
Not at this time, Your Honor.
Mr. Wyatt, so Ms. Worka, of course, is also asking for attorney fees. So maybe you can, maybe there's a sum that two of you can agree upon to make this thing go away. Obviously, this motion would not have been necessary if you had complied with the terms of the judgment. So and with that said, we'll see you on July 21st at 2:30.
Okay.
Thank you, Your Honor.
Contractually, we are about to hit 1 hour, and that is all that's in my I'm joking. I don't have a contract with myself. I think the rulings today were frustrating, but so is family court. Family court is frustrating. It is not often, you know, oh fuck, what's the word? Relieving? No. Joyous? I don't know. I don't know. We do need a period fence emoji. That's a good idea, actually. I think that's a good idea. Hi, Deborah. Oh, I did have one other case that I wanted to show you. Should I do one other case? Should really. Satisfying. That's what it is. It's rarely satisfying. Thank you. But peaceful is also a good one. Satisfying, logical. But it's rarely satisfying. It is most often not. Okay, give me 1 second. I got this. Yeah, okay. All right. Okay. I have tacos on the brain. All I can think about is this fucking taco salad that I'm gonna make. Oh, well, welcome, Deborah. We are a fun bunch around here. We are a bunch of fun people. I don't know what else to say, but I'm so glad that you're here. I go live pretty much every single day, twice on Sundays, and we're all pretty much addicted to watching court. So make sure that you've hit the subscribe button. Also, if you happen to like just court without the talking, which is fine, but like we like the talking part, I do make videos that don't have me in them, just so you know. Twice on Sundays, baby. Okay, let's do this one. Love it. Welcome. Oh, also, we have a pretty annoying bot called Streamlabs. There's
Hey,
lots
good
of fun shit
afternoon.
that goes on. Hold on. Judge, wait. There's lots of craziness that goes on in the Streamlabs chat. There's gambling, there's points, there's lots of commands. Did we add a period fence command? I don't know. And we love chicken. We love everything. We're weird. What kind of dressing goes on a fucking taco salad? Funny, I wouldn't put a dressing on the taco salad. I would use meat, sour cream, and salsa. So I guess I would make my own type of dressing on my fucking taco salad. Sour cream, right, Bev? Yeah. Yeah, yes. Oh yeah, gobble, not gooble. But we should make one for gooble too. Okay. Hot taco sauce. Oh, that's a really good idea. Oh, Deborah coming in here helping us out. First time. Paul's got a good point though. Southwest sauce is good. Well, get me the recipe. Oh, did I? I knew he would. But yes, we did that yesterday. That is so yesterday. We had a fun time. Fun time. All right, let's watch this. Like I said, this is in 2 parts, and this is a friend of the court contempt hearing.
All right, Mr. Pulaski, what brings us here this afternoon?
Ron Pulaski with the Kent County Front of the Court, Your Honor, presenting Sincere Ellison. Mr. Ellison has 1 case at our office. The docket number is 2022.
I'm sorry, we're going to have to stop right there. Sincere? The name is Sincere? Okay. That's like naming somebody honest, right? Oh, you guys are making me hungry again, but it's gonna be okay. Tom and Jonathan are both late, but that's okay. But I do write it down. Please know that. Um, that, oh, right. I know. This case, it's not good. It's not good.
007404 DS. Sincere Ellison versus Deja Lawson. The case is charging at $431 per month support for one minor child. There is a order on arrears for Mr. Ellison to pay an additional $25 per month, making his monthly obligation $456 per month for current support and the arrears on this case. The current arrears balance, Your Honor, is $8,749.05. In regards to payments being received, since the inception of this case, we received 2 income withholding order payments. Those were received in February of 2023, one for $111.38. And the most recent payment was February 17th of 2023 in the amount of $43.57. We've had 1 show cause hearing so far and 2 bench warrants being issued on this case. And at this point in time, no prior contempts. I did have an opportunity to speak with Mr. Ellison, who informs me that he lives on 44th Street. He's moved since our last contact with him. I asked him if he knew the address on 44th Street. He advised me he doesn't know the address, but he's staying with his mom and stepdad. He's not paying any rent. He has just this one job. He was involved in some technical training with Job Corps, but due to an incident, I'm not sure if he's still going to be attending Job Corps. I'll let him address that. In regards to assets, he informed me that he does have a silver necklace. In regards to bank accounts, he informed us of having multiple bank accounts similar to a Chime or Cash App. He's not on any government assistance. There's no health or mental issues going on, no substance abuse issues going on. He's not on probation or parole and no prior felonies. Again, Mr. Ellison.
So then why aren't you paying your child support, boo? What the fuck is going on here? Oh, weird. Weird.
Reported to me that he was arrested at Job Corps when he was involved in an altercation with, I believe, a security individual out there. When I talked to him in regards to employment, he said he's still employed with Metro Club on Division. This is the same information that Mr. Ellison provided us back in June 21st of 23 when he was arrested on our bench warrant as well too. He was informed at that time that he would be released and moving forward to pay the $456 per month or report 20 job searches. Our last contact with Mr. Ellison was May of this year. May 8th, he contacted our office inquiring about a bench warrant clinic that we had put on, but he did not show up. Thank you, Your Honor.
All right. Thank you. Mr. Miller.
Thank you, Honor. I did have an opportunity to speak with Mr. Ellison. We talked about his current financial situation. I think a big part of the problem is that he's underemployed. He indicated to me that he works 10 hours a week. I advise it obviously that he get out and get another job so he can get some more hours, get some more money, and be able to pay this. And that's what he told me he was prepared to do upon release. When we spoke about the currently available resources and being civil contempt, he has to be able to use currently available resources to make a payment here or to get out and purge the contempt. He told me he's got a total of $40. That's all the money that he's got in the world right now. However, he did also indicate that when he was seen by somebody yesterday, they offered to put him on a $50 a month payment. He indicated he could do that. The court does have the option of sentencing or ordering 1 month payments, which is a $461. He wouldn't be able to do that. There's no sense in doing that. That would amount to what would be criminal contempt. So what we're recommending or asking for is take the $40 that he's got right now and then take him at his word, get him on that $50 a month payment plan until he can get caught up. Thank you.
Right, Mr. Ellison,
Yes, Your Honor.
anything you'd like to say?
I know I'm supposed to pay payments and stuff, like, but it's hard out there. Like it's hard. I know life is what you make it, but I be trying. Like I'm trying to get stuff together. Like around them times when I wasn't paying, I was homeless. We was homeless. We was really going through stuff. It was to the point where we had to live with cousins in Kalamazoo, live with family in Harbor. You know, people get tired of you staying with them. Sometimes they want their space back to themselves. And the places that I was living, I did have to pay little money to get them there so I could lay there. And then sometimes I had to buy hotel rooms because we was really like we just now getting stable.
Who is we?
Me and my mom and all of us, like we was all homeless. We used to sleep in cars, sleep at family member houses. Like we just got stable now.
Okay, how come you haven't had a full-time job? There's lots of jobs out there.
I've been in job court. Like when we was homeless, I signed up for job court because I wanted my high school diploma, and then I wanted to take trades, and I see they help me do all that stuff, what it can benefit for me. And I signed myself up, and they allowed me to come there. And I've been there ever since, but they pay me too. And then they was gonna help me with the child support because they say they got a little thing for child support they can help you with. But me, I was scared because I know I had warrants and stuff, so I know if they took me down there, they was gonna still lock me up. I was just scared.
Do you have any idea whether you'll be able to continue with Job Corps?
Last time when I was on the phone talking to the person from Job Corps, I got like a friend from Job Corps, and I called them when I was in here, and I asked them, did they want me to come back, or did they say I was done, terminated? She said they didn't say nothing about me, so I feel like I could go back. But what I told the other dude, I told him I might not go back because I need a job, like a career job, like a job that's paying enough so I can cover all these obligations I got to pay.
Well, as far as the $50 a month, that doesn't even cover your current support, which is $431. So, and I haven't heard that you've done anything to try to get that amount lowered. Let's see, this obligation was established in 2022. It looks like is the case number. So a couple of years. You had a couple income withholding orders. Neither of them, the payments came up to the amount of the full obligation. Did you show up for your hearing when this obligation was established?
I don't want to lie.
You go to court to talk about how much you were able to pay and what your income was and all of that?
I did that yesterday.
No. I mean back in 2022 or 2023. Did you show up for the hearing?
I can't say if I did or I don't really remember. I can't recall from all that.
All right. Mr. Pulaski, can you tell from the front of the court's records, was that a default order?
Just a second, Your Honor.
Sure.
What is going on in this case, you guys? Sorry, I'm trying to look for something at the same time. And do we think that $40 is enough? Do we think that she is going to let
Based what
him?
I'm seeing, I believe it is a default order. It looks like the custodial parent was involved, appeared. However, at that time, there was also a PPO issued against Mr. Ellison from being around her. So I'm not sure if that impacted him appearing, which I don't believe it should, but.
Okay. And can you tell, was the petitioner receiving public assistance, was that what generated this case?
Correct, Your Honor.
Okay. All right. Thank you. And is that person still receiving public assistance? Are you able to tell?
Since April of 2024, no public assistance involvement.
Okay. All right. And one more question.
Sure.
Would Mr. Ellison be eligible for the responsible parent program?
I believe he would because he lives here locally. The only issue we have in regards to that he has not provided us with an updated address. All he informed me was that he resided on 44th Street somewhere. So
Okay.
we might have some communication issues with Mr. Ellison.
Okay. And Ms. Gibson, would you stop the live stream so that I can ask him some questions about contacting him so that it's.
Don't you worry, baby. I was working hard today. Let me create frame for us while I get us the last part of this case. And I want you to tell me in the chat. First of all, make sure you're subscribed. Second of all, make sure you've liked the video or disliked, but liked. Third of all, tell me, will $40 be enough? No, I got the rest. Don't worry. Will $40? I was trying to catch it like this. I was trying to catch it like that.
To say.
Again, Judge, and especially given his circumstances, he talked about being homeless. That does make it difficult for him to make that $460 or $456 a month payment. I would advise, I think as the court has already alluded to, that he talk to the friend of the court, see if he could have his payment lower based on the change in circumstances. So I would take him at his word. If we get him into the responsible parent program, or to get out, search for some other employment to be able to get more money. But right now, the $40 he has is all he has to his name. So we'd ask that the court not exceed that. Thank you.
All right. Thank you. The court finds that a support order existed in this matter, that the defendant had notice of the entry of the order, that he has failed to comply with the order and an arrearage exists, that if the defendant had exercised due diligence, he would have had the capacity to pay all or some of the monies due and owing. The court is taking notice of the information Mr. Pulaski provided regarding no history of felonies, or other barriers, mental health or substance abuse, any other barriers that would inhibit his ability to find a job or hold a job. The court also takes judicial notice that jobs are.
Take judicial notice of $2 late fee from each and everything. Thank you so much. Thank you. Writing it down. Thank you so much. I mean, Judge Judy would say that, Deborah. I love Judge Judy. But this judge ain't Judge Judy. She ain't Judge Judy. You guys think she's gonna come down hard on him? We'll see. We'll see. We'll see.
Lots of them are out there. There's signs everywhere. So therefore, I will find the defendant to be in contempt of court, that he be ordered ordered to serve 30 days in the Kent County Correctional Facility, to be suspended in the event that he pays $40 to the front of the court, and that he report to the front of the court to the responsible parent program within 7 days of release, that he pay $456 per month, or report 20 job searches if he does not comply with the responsible parent program. If he does none of those things, another bench warrant is to issue.
If you can believe this gets worse. This guy just got the deal of the century. Purge the contempt for 30 days in jail by paying $40. That's nothing. Watch him insert his foot into his mouth here.
Did you understand all that, Mr. Ellison?
Yes, Your Honor.
Okay, so $40 to get out, report to the responsible parent program with the
Can I
front.
say something, Your Honor?
Sure.
I don't mean to interrupt. I'm sorry. I say $40 on there because it's a Wisely card. I got it from Job Corps. We get paid every 2 weeks from Job Corps, but I don't know exactly because some of my money they take some of the money off because stuff in there that you buy and stuff that you do in there, they take some of the money off. But it should be 40 on there, but it's not 40. It should be like 30 at least.
If you could borrow $10 or whatever from somebody, I mean, at 40, I'm really giving you a gift here, especially since you haven't made any effort.
It's
okay?
on my card. I'm able to.
I don't know what to tell you. I've made my decision, and I just expect that you will follow through. I'm giving you credit for everything that you're telling me. So
Okay.
you need to have to step up with that responsible parent program. All right.
Yes, Your Honor.
Okay. Anything further?
No, thank you, Aaron.
No, thank
Right.
you.
We're adjourned. Thank you.
Can you fucking believe that? I have never in my life. I'm disappointed. This guy, if he doesn't have any mental illness, any physical ailments, no addiction issues, and he's an adult, I'm really confused as to how he's not working. I'm not saying that he can get his best career, but he can get a job 40 hours a week, right? I don't understand. I just don't understand. That hair was crazy though, right? I know. Anyways, you guys, I love each and every one of you. I'm so excited to go make my fucking taco salad. If you're new here, welcome. I am so thankful that you found us. We'll be back tomorrow. I'll be back. Don't you worry. Maybe post some pictures of my taco salad later. There's a few things though that I will ask of you. If you can do me the solid, please remember that I love you, I am proud of you, and I will see you in the next video. Bye. There is a Discord. I'll post a link to the Discord. It dies every once in a while. So it could be dying now. I will post a link to it. Oh, good. And also, I'm terrible at responding to things on Discord. So send me a message. That's the way to get me. Thanks. Talk to you guys later. Love ya. Bye.